you're probably here because you either develop video games, want to develop video games, have a passion or interest for video games, or really like to listen to lawyers talk about legal stuff. But either way, you're here because you love video games one way or another and you want to be a part of this. So let's talk about the video game industry that we're all a part of, the Canadian industry. And as you can see, video games are a pretty big deal in Canada. $4.5 billion in 2020 in terms of revenue generated. Over 44,000 people are employed in this industry. A growth rate of approximately 60% year upon year. And over 937 studios in Canada, with the majority of them being in Quebec and in our own ones, Ontario. And well, Canadian video games are a pretty big deal on the global stage as well. We're the third largest video game developer market in the world. Tons of indie studios, tons of AAA studios come out to develop games here as well. And you're probably wondering, well, why is that case? Why is Canada such a great place to come and develop video games? Well, the reason is it's you guys. It's all of you. It's the talent in this country. We're home to a large pool of highly skilled and experienced developers, programmers, artists, designers, and writers. And it's a great place to start studios as well, because we've got a lot of funding and support from governments as well in terms of grants and taxes, which is something we'll go over in a little bit more detail. And so all of this has given Canada a very good and strong reputation at the global stage. It's a legitimate, full-fledged industry. And with legitimacy and with serious business come lawyers. So just wanted to say hi to everyone again, and thank you for attending this meeting. I want to thank Amar for hosting this event as part of IGDA, and George Brown College for hosting this room for us as well. So my name is Amar Sidhu, but you can call me Amar or Amar. And I'm a video game lawyer. I provide legal solutions, guidance, and protection to various stakeholders in the video game industry. But I'm also a gamer, and was a gamer well before I knew what a lawyer did or what I wanted to do. And I actually have a funny story, and you're probably wondering why is this there? But I wanted to be a video game developer, and technically I was before I became a lawyer. So when I was a teen, I used to use software called RPG Maker. I'm not sure if anybody's familiar with it, it's still around. And I used to make games, RPGs for my friends and give it to them for their birthday gifts. But as you can see, it didn't work out. That's why I'm wearing a suit and I'm speaking to you as a lawyer. But now I get to work with developers. And the beauty in that is now I get to help them build amazing studios and create some awesome games. So just before we kind of get into this, I have to do this, I'm obligated, so you don't get through this information. It's not legal advice. This presentation is for educational and informational purposes. And yeah, I'm not your lawyer yet. So we have a lot to cover. Law when it comes to video games, we could be here all day, we could be here all week and month. You can play all your favorite games over and over again, we'll still be here. But given the time, I figured we want to talk about some of the most important issues as they apply to the video game industry. And these are, well, how do you launch a studio? Funding, you can't do anything if you don't have money. Contracts, they're everywhere. Get used to it. And intellectual property, which is probably the most important area of law when it comes to video games. So we'll start with launching a studio. In Canada, whether you're starting out a variety of different ways, we have generally three main types of entities to start your studio. Arguably, there are more, including co-ops, which are becoming more popular, especially in Toronto. But we're not going to get into that because you could have like 3 presentations just on that. But each entity has its pros and cons, as you can see. The most common are sole proprietors and corporations. So sole proprietors are, maybe for solo devs where they're just starting out, the business, the studios under their name. Whereas corporations, it shows the world that you're taking this seriously, that you're willing to create a separate entity to basically run your studio out of. And if you're serious about it, it's probably the way to go. And here's why. There's a lot of benefits that come to incorporating. It's limited liability, probably don't know what that is, but essentially you are not on hook personally when it comes to the things that your corporation or your studio is doing. It's your corporation. Clarity. You're not mixing your funds, your ownership rights with yourself personally. You can store all of that with the corporation, and everybody knows that this corporation is created for your studio specifically. Funding and tax credits. A lot of opportunities are only available to corporations. They won't give certain funding opportunities to sole proprietors for transparency reasons, because at least with a corporation, you can prove that the money, the funding that you're receiving, I know, can you really prove it? I don't know, but it's going into the corporation, whereas with a sole proprietor, it's going into the personal bank account. And as I mentioned, it's an entity. So when it comes to creating video games, you're going to be working on a lot of different IPs, so intellectual property. And this is going to be the one place to kind of store all that IP. So if you have multiple developers, artists working and developing different IPs, instead of those rights attaching to each one individually and wondering whose it is, the corporation or the studio itself will take all of that. And for investment, so if you're looking at outside investors, they will only really deal with a corporation, because corporation is a vehicle that allows investors to actually receive shares or equity in very interchangeable terms in return for the investment. It's like proof that we've given you money and now we're getting shares in return. And it also means you have to share, like literally share with investors in your studio. Corporations are better for contracts. Again, you yourself aren't entering the contracts yourself. The corporation is going to be entering on your behalf. And as I mentioned, it shows the world that you're taking this seriously, and they in return will take you seriously. So there's a variety of ways to incorporate these days. A lot easier than it used to be. Before, you'd have to go to a lawyer, spend a ton of money, because essentially you had a monopoly over incorporating. But nowadays, you can do it online, you can do it yourself. You can go to Corporations Canada website to set up a Canadian corporation, or you can go to Service Ontario and set up a Ontario corporation. There are some differences, but for the purpose of this presentation, we won't get into it. Let's just say that if you plan on having a studio with a global presence, you'll want to go with a Canadian corporation. And there are many other reasons, but just to keep it simple. You can also use third-party services, such as Owner, where they will go through the whole process of incorporating, as well as other additional stuff that lawyers are usually involved in. It is important to note that if you do decide to incorporate on your own, you'll basically just set up a corporation. There's a lot of other steps that you have to take in order to, actually comply with the laws involved with running a corporation. And so that's where lawyers are so involved. We can take care of the whole process for you, so you don't have to waste your time thinking about how to do the legal stuff when you just really want to focus on creating your game. So, funding. I mean, it's going to be pretty hard to build a studio, hire staff, release a game, and if you don't have any money. So let's go over some of the important things to know about funding. Where to find funding. So there's a lot of places that you can look and realize in order to find funding. And I know it's sometimes like, where do I fund the money? But these are some places that you can start with. Like I mentioned, in Canada, it's great that we have grants and government funding, tax credits. We can seek investors, probably not as great as it is in the US, but we do have some. You can go to publishers, friends and family, crowdfunding platforms, and merchandising. And now some of these, you can, like for example, with investors, publishers, friends and family, crowdfunding, You don't have to limit yourself to the Canadian market in order to get funding. You can go abroad. You can get investors from outside, and a corporation allows you to do that. And the key thing here is don't focus on just utilizing one way to get funding. Try to take advantage of all. Use them. Get as much money as you can. Just make sure that when you're signing agreements with them, that you know what you're signing. You're not selling your soul. You're not selling your game away. You might, because with publishers that might be the case. And so, in terms of formulating and understanding how to get funding, how to even start, well, you can think about it in two ways: it's project funding and company funding. So, project funding is game specific. Game focused, project focused. And this is typical when you're making like a traditional game where it's like 15 hours, 20 levels, and it ends. Yeah, DLC is included as well. But this is as opposed to, say, company funding, where this is more so where the funding is more focused on the long-term vision of the studio. This is a studio that's going to be churning out games, different types of games, but also working on games that, games as a service that literally don't end, in online multiplayer games. But when you are seeking company funding, remember, you might be sharing equity and shares with your investors, and giving over some rights. So make sure you understand that you're going to have to share and that you're okay with that. And then we have grants and recoupable advances and tax credits. So a reason why the Canadian industry is doing so well is we do have government support when it comes to grants and tax credits. But not all of these are free money. For example, like Canada Media Fund, these are recoupable advances, which basically means they want to get paid back at the end of the day. They're giving you the money on certain terms, and depending on the sales and the revenue generated from the game, they're going to want some of that money back in some form or another. Whereas tax credits, on the other hand, they're great. Quebec is probably the best place in the country when it comes to receiving tax credits. So maybe considering if you are looking to set up, Quebec is an opportunity. But Ontario is pretty good as well. And just make sure that when you are looking to get tax credits for funding, that you speak with your lawyer or your accountant to make sure that you are properly set up. Because a lot of these do require you to have a corporation as well as to hire certain types of people in terms of like Canadian quota or employees quotas and stuff like that. Yourself, I mean, technically you're the first investor in your business, and you're going to be, putting a lot of out-of-pocket money into the development of your game, whether that's your first PC, your first studio, the space that you're renting out. So you want to make sure that you're paying yourself back for that in some way or another. If you set up a corporation, you can do that by issuing yourself shares. That's also known as sweat equity. Or you can also look at family and friends. Of course, this depends on the kind of relationships you have with your family and friends, but it's a good place to start. And they probably don't care as much about getting a return on their investment as much as they do about helping support you. Just make sure that you maintain those relationships with your family and friends, because it could come to bite you in the future. And also consider having something in paper. You don't necessarily need to have like formal agreement with family and friends, but something to show that, hey, you gave me some money, and I'm going to pay you back for that sometime in the future. Publishers, this is super complicated. Like, we can have a whole separate presentation just on getting funding from publishers. But it's probably the most famous and traditional way in the video game industry. There's some good, there's some bad. But having said that, today, with all the self-publishing options out there, you might not necessarily even need to work with publishers to get your game out. But if you use them, they can be extremely helpful. Yes, when you do get involved, the negotiation process is really complicated, and it does require some sort of agreement if it doesn't run away. Because trust me, you're not going to get your game You will end up having to give up some types of ownership rights to your IP. Revenue, you're going to be sharing that. You might not even get it until the publishers get paid back first. They might even have the rights to your game or the IP to like sequels and derivative works in the future. And high expectations. But on the positive side, publishers are known for being very generous, giving significant advances. And if they are deciding to work with you, that probably shows that they believe in the project that you're working on. They've got industry experience. They can add talent to your existing team, which could go either way, but it could be seen as a boon. They have prestige, and they can take care of a lot of things that developers just don't want to focus on. Developers just want to focus on getting the game out the door. Publishers can help take care of everything else, from marketing to distribution. And then we have investors and other funding. So most companies in general, when they're looking to raise money, whether they're startups or whether they're even publicly listed corporations, they get money from investors. And the thing is, the key to investors is that investors don't really care about why you're making a game or the game itself. They care about getting a return on the investment that they give you. So that's always something to keep in mind. And so, having said that, working with investors can be difficult to get. You have to hustle, you have to attend a lot of meetings, you have to do a lot of pitching. And it always helps if you do have a corporation. I do think it is a requirement because you have to have some sort of structure to give them shares or equity in return for the investment. And the key is just have a detailed plan of what it is that you want to do. And a strong pitch, a strong vision, and show them that you're committed. Because if you can show to them that if they invest in you, they will get a return on investment, whether it's in this project or whether it's in projects down the line, they'll probably be sold. And in terms of types of investors, we have venture capitalists, we have hedge funds, we have investor firms, but we also have angels. And angels they're different. They're individuals who have come into money or already had money, but they're investing more for the emotional aspect. So typical investors in the video game industry, they're most likely already in the tech space. They might be based on Waterloo, they're in Toronto, Silicon Valley, and maybe they successfully sold an app or a company and they have money to invest. And so they will look at some of the developers, especially local developers to their area, and they'll help give some support. And in terms of investors, they're probably the easiest to deal with. We also have other types of funding, so crowdfunding like Kickstarter, but it does require a lot of work, right? You have to actually create the campaign. You might end up having to hire marketing to pitch and promote your Kickstarter campaign. So when you are looking at crowdfunding, make sure that you weigh the costs and see if you're actually going to get money in the end. Incubators and accelerators, these are common for startups. But in Quebec, they have execution labs, Indie Asylum, that are specifically just for video game developers. And some incubators here in Ontario also host video game developers as well. I work with The Forge, McMaster, and we have a couple of developer studios as well. Although that isn't the forte, I would urge to look into them to see if you can get some support and funding. And merchandising, selling clothes, accessories, toys, figurines, artwork, soundtrack, basically using the intellectual property of the game, but for other purposes, the other aspects of the IP. And I mean, if you want to risk it, you can also use NFTs, but be careful because, yeah, the law on that is a bit murky. And that takes us to contracts. Super important. Nowhere near enough time to speak about all the types of contracts. Here's why. There's tons, and that doesn't even cover all of them. But the thing is, contracts are important, and yes, you do need one. And it's best to have one before you do anything, especially rather than after the fact. And an example would be, let's say that you're looking to work with a publisher or a distributor and you're signing an agreement with them. They're going to make sure that you have acquired all the rights to the IP that are in your game. So let's say that you work with a freelancer or some studio that's abroad, and you didn't have an agreement with them to secure that IP. Well, you're going to need to in order to get that deal with the publisher. But if those individuals that you work with realize, okay, you're getting a lot of money and there's no agreement, they can leverage that IP over you. And it's going to end up costing you a lot more. So make sure that when you do work with contractors or anybody outside your studio, that you know who is doing what and who is getting ownership of the IP. So yeah, get familiar with all of these, but there is a way to understand them that makes it a lot easier. And here's why. Relationships. Contracts are all about having clarity with all the relationships that you, your studio, your game, have with everybody else who's involved with you in the game at any capacity, at any time. So you can think about it in terms of like 5 types of relationships. And you can feel free to sub studio with the game. So relationships within the studio, relationships that the studio might have with third parties, with a partner, with investors, and with consumers. There are many more relationships that you can think of. Literally, it's if there's a relationship, how do you define that relationship? But these are sort of the main 5 to think about. And you can see that some of the contracts here, they fit into each category and then you don't see them again. But some of them, like NDAs, they show up. And we'll focus on that in a little bit to explain why. And while there's so many contracts that we can talk about, we're going to focus on just a few that I think are critical. So we have non-disclosure agreements, service and independent contractor agreements, development and publishing agreements, IP licensing and assignment agreements, EULAs, and terms of service. So starting with non-disclosure agreements, NDAs, are also known as confidentiality agreements. They're meant to protect the confidential information about the studio, the game, the IP, and the business in general. And it establishes that confidential relationship between 2 parties, the one party being the studio or the owner of the IP, and then the other person that you're engaging with. And these are some of the key things to know, that it does protect confidential information, that there's unilateral, multilateral NDAs, literally meaning that there are one-way NDAs, and then there's also mutual NDAs, that let's say you have a conversation with someone, whatever information you disclose to them, that's confidential, but whatever information they disclose to you, that is confidential as well. And while that might seem like a good thing, that could have some problems, especially with certain developers. And so if you do have conversations with anyone, lean towards the unilateral type of one-way confidential information, because you don't want to have to be burdened by not sharing the conversations you had with the publisher, because they have a lot more information than you do. You just want to focus on protecting and securing your own information. So there's a lot of ongoing debate whether NDAs are still relevant or still should be used. And while investors will probably be the ones to tell you that you don't need to use them anymore and that we don't need to sign one, you probably should try to sign one, and I would recommend it. Because when we talk about IP, you'll realize how complicated IP is, and that certain things can be protected by law, but other things can't. And you need an NDA to protect some of that information. So let's say that you have a conversation with an investor or a publisher and they refuse to sign an NDA. Well, let's say 4 or 5 years down the road, you've poured like your heart and soul into a game, and then just as you're about to release it, you find out another studio releases the exact same game. Well, it's probably because there was a leak of confidential information somewhere, and it's going to be very difficult to figure out how to solve that problem. So if you can, use an NDA. And you can boost your chances depending on how you utilize it. So plan ahead. If you think you're going to have a conversation with an investor or anybody that you're going to be discussing confidential information, reach out to them. Say, hey, I've got an NDA. I'd like you to sign this. And do this about a week or so in advance. Because if you just drop it on them right before you get into the meetings, and I'm not going to talk until you sign this, they're going to tell you to go out the door. So plan ahead. Then we have service and independent contractor agreements. So these are also known as work for hire agreements in the US or freelancer agreements. And if you do end up seeing a work for hire agreement come across your desk, just make sure it cites Canadian law. Because I've had a couple of clients come up to me and say, hey, we got this work for hire, maybe they've signed it, and it's American. Which is okay if you're working with American parties, but if you're working with Canadian locals, it's not really going to help you much. But essentially, independent contract agreements, service agreements, they allow you to enlist the service and help of others to help you develop your project. So not necessarily employees within your company or your studio, but a friend, somebody you know who's good at, has certain talent and can take care of one of the aspects for you. For example, creating character models. You would have an independent contract agreement. Yeah.
Should I save my question to the end? Or
yeah, that would be great. Yeah, thank you. But the key thing with independent contract agreements and service agreements is to outline what is the relationship, what are the expectations. So one, what are they doing? What are they creating for you? How are they getting paid? But most importantly, who in the end owns the IP that is being created? Whether that's being fully assigned, transferred over to the company, or whether the company or studio is receiving a license, whether that's exclusive or non-exclusive to use it. We also have development and publishing agreements, probably one of the most important, complicated agreements that a developer is going to come across. Basically, it governs and articulates the relationship between the developer studio and a publisher, or another studio or an investor or some body that is basically hiring a developer to create a game on their behalf. And this covers almost every aspect of the video game development, from who gets the money, from funding, early phase development, teams, control over decision making, sequels, ownership of IP. They think that you have an amazing IP, they might hook that IP for like 7 to 10 years down the road. So be careful about the types of terms that are in here. I have put together a free tip sheet if you do end up having conversations with publishers, how to prepare to have this conversation, because you have to go into the mindset of knowing what it is you want. Because publishers, they have a lot of experience. They have bigger legal teams, and they are always going to try to negotiate what's best for them. So make sure you go in knowing what you want. IP licensing and IP assignment. So again, very important. Essentially, you need a contract when it comes to assigning IP. There's no way of saying, yeah, you have the IP, here you go. It needs to be articulated in some sort of a physical written agreement. And you'll understand, as I mentioned, when we get to the IP side. But essentially, this ensures that you have the right to use the IP in your game. Whether this is licensing with third parties, like musicians, composers, if you're making like a sports video game and you want to have the names and teams of official athletes, then you're going to be looking at the owners of popular IP and brands. So if you're making a game and you want to have, I don't know, like a Nike hoodie in your game, you better make sure that you have the right to use Nike's IP in your game. And then EULAs and terms of service. So this is to make sure you protect yourself from the players, the consumers of your game, and that they don't end up exploiting your rights to the game. So these include things like imposing legal obligations on players. You know, what can you do, what you can't do with the game. Controlling your liability. If you don't have a EULA terms of service, something goes wrong, technically the consumer can sue you. A license agreement, you have to remember that when a consumer purchases a game, they don't purchase a game and say, well, I own it. They receive a license to be able to play the game. The studio, the publisher, still owns the IP to that game. And that license agreement articulates that license that consumers have to be able to play with it. Rules of conduct, what can you do, what can't you do playing this game. IP rights, such as user-generated content, which is super common these days. There's a lot of games where users are now creating their own content. And now the question is, who owns the content? Is it the studio, the people who made the game that allowed the user to create that? Or is it the user themselves? So you need to make sure that you have in a EULA or a term of service some sort of a language to confirm this is how user-generated content is going to be treated in this game. Same with virtual currency and items. The last thing you want is somebody to say, well, I've got $1 million in Grand Theft Auto, and go to the company and say, you owe me $1 million. You have to outline how virtual currency is treated, that it's just for the game and it has no relevance outside the game. Age restrictions, which is becoming more and more important, as you can see with what happened with Fortnite recently. Limiting the liability, as I mentioned before. And the key thing is, if you have a EULA in terms of service, you have to make sure that the users have some sort of an interface where they're scrolling through. I mean, you've all seen it before, and then they agree to the terms and conditions of the EULA. Because if you don't have something like that, it's harder to enforce the fact that they did agree to your EULA. And this takes us to our next and final topic, and arguably the most important topic of law when it comes to video games. So, have any of you seen the movie Indie Game, the movie? Yeah, so there's a quote in there from Phil Fish, a developer from Montreal, made Fez. He did that with government grants, by the way. Who summarized the relationship between video games and IP. It's like my favorite quote from the movie. He says that games are the ultimate art form, the ultimate medium. It's a sum total of every expressive medium of all times made interactive. When you think about it, video game isn't just music. It's not just character models and art. It's not just the story, the script. It's everything, and then you can go in and explore it and interact with it. It's beautiful, and ultimately, it's IP that is your expression of yourself and what the world means to you. So not to get all sentimental and philosophical, but it's a pretty big deal. And so your IP is a part of you as a developer, and you want to make sure that you have a say when it comes to your IP. So that's why this area of law is critical. So IP is essentially real rights for intangible things. So music, you might not be able to hold music, but we know what music is, and then it comes on different types of formats, like a CD or digital files these days. So it's giving rights and protecting those types of rights. Your game is a piece of IP, but so is every single layer or piece that makes it what it is. And so in Canada, we have multiple ways to protect IP, and it's protected at the federal level, so across the country it's the same standard that applies. And we have a Canadian Intellectual Property Office, which is the place to go to. They sort of govern this area. So if you're looking to register copyrights, trademarks, file a patent, you would go and do it with them. And depending on the category of intellectual property, there might be statutes and common law to enforce that. So statutes are essentially laws that the government passes and makes official. They're hard to challenge. They're essentially, it is the law is what it says it is. And then common law are basically legal principles that are developed through court proceedings. So if courts have certain judgments on things, that ends up becoming the law. And the key thing with intellectual property is to understand it, secure it, and get on it as early as possible. You have to be proactive because nobody's going to police your rights to the IP. You have to go secure and enforce it. And I've got a picture here of Travis Scott at Fortnite from a couple of years ago. But it kind of summarizes like how wild IP and video games can become. So if you think about, okay, there's all the levels of IP in a video game itself, well then this is what happens when you combine it with other types of art forms and IP. The sky's the limit in terms of the combinations that you can come up to, and I'm sure you guys are going to come up with some crazy stuff soon. So copyrights, these are most common types of IP, and they're protected under the Canadian Copyright Act, or Copyright Act of Canada, as well as common law. So it protects creative work that has been drawn, recorded, written down. And some examples of these are character models, codes, art, music, sound, animation, UI design, writing script, and like I mentioned, the game itself. And an interesting thing is copyright is on that. So if you draw a picture and then publish it, you have a copyright to it. It's yours. But you can also register it with SIPO, and that's highly recommended because the government has proof that you are the copyright owner. Otherwise, if you do want to sort of go after somebody and say, hey, you're copying my thing, you have less evidence of it, essentially, to prove that you do own it. Whereas if the government has your back, it's hard to kind of prove otherwise. And it's not that expensive to register as well. You can do it yourself by going to SIPO, and it's about $50 to $65 to copyright it. And trust me, that's low compared to like patents, which are like $15,000 to $20,000 to register. And an important thing is, once you have protection in Canada, you also have protection in 176 countries that are signatories to the Berne Convention. So that's like the US, China, Japan, European Union members as well. Oh, and if you want to know more, I also have a video that kind of deep dives into that. Moral right. So this is a part of copyright law. And it's tricky, so it's important to understand because this is something that can't be transferred or assigned. So when an artist or a creator creates something, nobody can take away the fact that they ended up creating it. They can sell it to someone, they can assign it, but they'll always have this thing called a moral right. And the only way that a studio or developer can end up not having to deal with it is by getting that author or that creator to waive it. And they have to waive it expressly through some sort of written form. So the best way is if you are working with contractors or your employee, make sure the agreement that you have with them has language to waive the moral right. Because for example, if your video game is associated with something that the artist believes goes against their artist's integrity, they can invoke it. And that might cause a problem because it might cause you to take down your game or take out their music or whatever piece of art it was that they contributed. So it's tricky, but also easy to deal with if you do it beforehand. Trademarks, another common type of IP for video games, and these are protected under the Trademark Act of Canada, as well as common law. And this is a combination of letters, words, sounds, designs that distinguish a company's products or services from its competitors. So I'm sure Mark is familiar with that one, EA Sports. Nintendo. And the way to secure or implement protection for trademarks is, well, one way is through common law, which is basically build your brand so that it's strong enough so it's hard to associate that term or that logo with anything else but your brand. So that's kind of what EA's done here with EA Sports. They just have a TM logo, which is the common law way of protecting trademark. As opposed to Nintendo, where they've gone ahead and registered that trademark with CPO, with USPTO, which is the US version, and then they get that fancy R symbol. The thing that's different from copyrights is that you have to register a trademark in every single country that you want protection. So if you have one registered in Canada, it doesn't mean you get protection in the US. So that's something to be aware of, and also think about strategy-wise, if your market is the US, it might not be a great idea to register a trademark in Canada, but maybe focus on the US market. And also, pro tip, plan this as early as possible. Do your research, just Googling names, seeing if it's been taken, that goes a long way. Why? Well, let's say that you're about to release your game and you have a title for your game, all the marketing stuff is done, all the physical copies are done, and then all of a sudden you get this cease and desist letter from somebody who owns the trademark, the name used for your game, and you can't use it anymore. So if you're settling on a name, make sure you do your research, and if you don't want to register a trademark, try to pump up the brand as much as possible so it's hard to distinguish otherwise. And this is an example of a trademark that's registered by Ubisoft for Assassin's Creed. So this is how you know. You go to the CPO website to define this, and you can see that it is registered. It's live. It was filed in 2007, but registered in 2008. So it does take time. This is actually pretty fast. Nowadays it takes 2 to 3 years. You also see that it's expiring in 2023. So that doesn't mean that you can hop on and claim Assassin's Creed for your own trademark, because yeah, Ubisoft undeniably has strong common law right trademark to Assassin's Creed, but you can try it. Trade secrets. There's no formal statute, like there's no Trade Secret Act of Canada, but the way to protect this is through using common sense. NDAs, this is where they're the most important, because they protect the formula, the pattern, the physical device, the idea. And idea is related to the software. So for example, some idea that you might have, concept, as long as you can prove that if you acted on it, that would give you a competitive advantage, you can claim that as a trade secret. And Coca-Cola is probably the most famous trade secret there is. There's like a select few of people who actually know what the formula is, even though other people might claim they do. And that, there's no limit to trade secrets in terms of being protected. And it's almost been protected for about 130 to 140 years. So we don't have too much time to talk about patents, so we're going to skip over this. Really, they apply if you're working on hardware or inventive gameplay mechanics. So think of like the dialogue wheel from Mass Effect, or the Nemesis system from Shadow of Mordor. Something that's inventive, and it gives essentially the developer a right to stop anybody else from using their inventive gameplay. So probably nothing that really applies to anyone here. But if you have the money and you're coming up with something crazy, it might be worth consideration. So what are some tips that solo developers, small indies can use? Well, I would suggest starting by copywriting, because it's quick and easy. Registering 1 or 2 of your trademarks, like I mentioned before, if you're focusing on a title, whether it's the title of your game or your studio's title, that might be one of the things you want to register a trademark for. Have an NDA, and have one that's specific to your game or studio. You might be inclined to go and go on the internet but it might not actually make sense for you. So make sure that you do have one that makes sense for your studio as well as your game. And add IP clauses to your agreements, because at the end of the day, you need to make sure who owns the IP. And a little bit of a cheat sheet, because there's all different types of IP and probably wondering where they fall. These are some examples of how they apply in the video game industry. So we mentioned music code, but website design, that's a copyright that you can claim for your studio as well. Trademark, it also includes sounds. So like EA's, it's in the game, that's a trademark. As well as like Nintendo's D-pad. That was something that they patented. So those are some examples of patents as well in the video game industry. So this kind of brings us towards the end of the presentation. And so you're probably wondering, well, what do lawyers do? I explained a lot of stuff, but what can we do to help with the process? Well, if everything that I've covered in this presentation has blown your mind or you don't understand it, lawyers can help you with all that. Especially lawyers with experience in the video game industry, or lawyers who understand what games mean to developers and speak the same language as developers. We offer solutions. We can guide you through the process that you're unfamiliar with. And we can also help you with the strategy for long-term planning. And of course, we can protect you. When things go wrong, we've got your back. So I just want to thank you all for attending this presentation. I hope you found some of this information interesting, to the very least. Again, my name is Amar Sidhu. My email address is amar@amarvrlaw.com, so please feel free to ask any questions if you do have so after this or in the future. I'm also on Twitter and Instagram, and I have a YouTube channel where I kind of go in depth in some of the topics that we talked about if you're interested in learning more. And that's everything.